All right, y'all, let's go. Hold on, you see how I got my two screens? That's my trademark, yo, that's crazy, what we getting ready to talk about. So, when I shoot these videos, I like for my logo to be showing so that I'm promoting my logo at the same time. So hold on a second. Come over here, do that. All right, bring that down. Now we got both logos going. What's going on, man? Sean G, don't never stop. I got the dope cold coffee, that coffee cold. Gumby Publishing, Stigmatism in My Soul. The podcast was sold. Me personally, Sean Xavier Gumby Sr., I do not wish to slander, libel, defame, or hurt anybody with the content that we're going to talk about today, which is going to be court documents. This is a 43-page document that's available to the public on pacer.org. This is the Ricky Donnell Ross trademark and identity theft case filed against William Leonard Roberts II for misappropriating his name and his trademark and trade name. So, this is part two. So, what's important about this part, and this is the underlying crux of what Ricky Donnell Ross was suing. Ricky Donnell Ross is the real Freeway Ricky Ross from South Central Los Angeles, who was the major drug trafficker in the United States in the 1980s, 1990s. William Roberts is from Miami, Florida. He's the rapper that misappropriated Freeway Rick Ross's name and built a rap career fraudulently using the dude from California's name, who was a real drug dealer, versus William Roberts, who was a corrections officer in Miami. So, now, what Freeway Rick is talking about in this particular portion of the complaint, this is a 43-page document. The case number is 2:10-CV-04528. You can pull that down online. This is public information. So, Rick D. Ross, in this complaint, has filed sent letters to William Roberts, Def Jam, Universal Music Group, Slip and Slide Records, Maybach Music, Jay-Z, Sean Carter, to cease and desist from using his name, right? Because not only is this his real name that his mother gave him, right? You can file a trademark and trade name patent if against your real name, if your name takes on a secondary meaning, which we're going to talk about here. So like with me, right? So I'm Sean G. My name is Sean Gumby. That's on my birth certificate, right? So like my name with my YouTube platform, in over 130 million views worldwide, is maybe even be more, has taken on a secondary meaning, right? Not only am I just Sean Gumby, whose name is on the light bill, right, or on my cell phone bill, I'm Sean Gumby, the social media guy, right? So it's taken on a separate meaning, and I've been doing this for 8 years, since 2016. So that's what Rick Ross is trying to establish. That's what he clearly establishes. Let's get into it. In trademark law, secondary meaning or acquired distinctiveness refers to when a term or name that is initially descriptive or generic gains protection as a trademark because consumers primarily associated with a specific source of goods or services rather than the goods or services themselves. Now, acquired distinctiveness. This I got down off of Google. You can just Google this. You could Google trade name secondary meaning. Acquired distinctiveness. This occurs when a descriptive term, through extensive and exclusive use, becomes a symbol that consumers recognize as representing a specific brand or source. Proof of secondary meaning. To prove secondary meaning, evidence such as consumer surveys, sales volume, advertising expenditures, and the duration and extent of use can be presented. The importance of this: acquiring a secondary meaning allows businesses to protect their brand identity and prevent others from using the same or similar terms that could cause consumer confusion. That's what Rick Ross sued William Roberts for. Now, in this part of the criminal complaint filed in federal court in June 18, 2010, it is expressly highlighted in here that William Roberts, the rapper, tried 6 times to patent the trade name Rick Ross. 6. He tried 3 times with just the name Rick Ross, was refused across the board, received a letter, final refusal, don't send no more. Then he changed the logo, put on glasses, the beard, and a shadow behind the logo. Filed that one 3 times. Refused all 3 times. So the United States Patent and Trademark Office was unequivocal and let William Roberts, Def Jam, Universal Music Group, Maybach Music, Jay-Z, Sean Carter know from the gate. Just legally, you cannot use this name because you're trying to patent it and trademark it, and we're telling you no. But they continue to use the name anyway. Freeway Rick Ross is suing them for $10 million in damages. Punitive damages, punitive, compensatory, and treble damages, right? So whatever the compensatory damages is, when you get treble damages, that means you get 3 times. Treble means 3 times, okay? Let's get into it. Page 16 of 43. Common law and federal trademark and trade name infringement. The plaintiff, Ricky Donnell Ross. Defendant, William Leonard Roberts II. Plaintiff Ricky D. Ross is the original and lawful owner of his birth name and his abbreviated and trademark name, Rick Ross, which is the real name he has always used his entire life as a young tennis player and his past criminal life allegedly as a businessman in the illegal drug trade, and plaintiff continues to use his Rick Ross name since his 1995 imprisonment to the present. He's known as Rick Ross, Ricky Ross, Freeway Ricky Ross. Paragraph 33. Under U.S. federal trademark law, a trademark is defined as any word, name, symbol, device, or combination thereof used to identify and distinguish his or her goods from those sold by others, and to indicate the source of the goods, even if the source is unknown, and trademarks need not be registered, but they must be lawfully in commerce. A trade name is defined in common law as any name used by a person to identify his or her business or vocation. Ricky Ross is the sole owner of his trade name and his unregistered trademark, which is his name, Rick Ross. And Rick Ross's trademark and trade name has acquired a secondary meaning. Remember, we just talked about that. Acquired distinctiveness. Since it is clearly identified with his past life as an alleged major drug dealer, and such secondary meaning is proven from use of his name in commerce in interstate drug prosecutions in federal and state criminal courts, and formal congressional hearings into drugs and crime in American cities in the 1980s and 1990s. Paragraph 36. A personal name may be protected as a trademark if it acquires a secondary meaning, and the plaintiff, Ricky Donnell Ross's name, acquired a secondary meaning by 1996, at least 10 years before William Roberts' first use in commerce in 2006. The plaintiff established his Rick Ross trademark and trade name by engaging in unlawful drug commerce in California from 1980 to 1995. He no longer engaged in unlawful commerce, and he used his name lawfully in commerce from 1999 to the present. In February 1999, he formally authorized a movie about his life using his name, Ricky Ross, his first lawful use in commerce. Paragraph 38. Ricky Ross was reportedly known in Los Angeles law enforcement and criminal circles as a major drug kingpin until 1995. And amongst his peers, Ross established his real name as his trade name in commerce for more than 15 years, which is 10 years before William Roberts and the other record companies used Ross, his trademark and trade name, competitively in commerce years prior to. William Roberts' use of Rick Ross's name is to create the false character and rap identity the defendant William Roberts created and named after plaintiff Rick Ross, that Rick Ross never granted, never assigned, or never authorized the use of his name, trademark, or image to defendants. Paragraph 41, page 19 of 43. At some time after 1995, when defendant Roberts was a college student, or after he became a correction officer in 1996, at around the same time, plaintiff Ricky D. Ross was finally incarcerated for his illegal activities in interstate commerce. The defendant, William Roberts, allegedly claimed, used, or began exploiting and misappropriating plaintiff Rick Ross's trade name, trademark, using Rick Ross's name and drug dealer image publicly as his rap name. And Roberts did so with the purpose to commercially exploit the name's value in the rap music industry by linking his rap image with Ricky D. Ross's criminal past, reputation, and image for the value associated with plaintiff's name. Paragraph 42. Plaintiff's common law, federal trademark, and Rick Ross trade name was infringed upon and violated by the defendant William Leonard Roberts II, who trades as, did business as, and performed as the ex-drug dealing rapper named Rick Ross, fraudulently with intent to knowingly deceive the public about his true non-drug correctional and law enforcement background. Beginning in August 2006, William Roberts, by and through his attorneys. This is the part, y'all. This is the part. Beginning in 2006, defendant Roberts, by and through his attorneys, attempted to register with the United States Patent and Trademark Office by filing an application for registration of a mark, Rick Ross, 3 times, then tried it again January 14, 2009, using Rick Ross' name with the silhouetted facial image in black with a beard, mustache, and shaded glasses on white 3 more times for a total of 6 attempted registrations. However, none of the defendants' attempted Rick Ross registrations were approved by the United States Patent and Trademark Office, and after a final refusal of the name registrations by the U.S. Patent and Trademark Office, and an initial refusal of the most recent 2009 name and image registrations, but no final determination. So he tried to register, William Roberts, the rapper, tried to register and trademark the name Rick Ross 6 times and was denied 6 times, and sent a letter from the U.S. Patent and Trademark Office that this is the final refusal. Don't send nothing else down here. Don't send nothing else down here. William Roberts and Def Jam, who signed Roberts to a major record deal early in 2006, should have known about the trademark applications filed by or for defendant William Roberts, or participated jointly in Roberts' attempt to register Rick Ross's name as William Roberts' trade name, which conduct was intentional, tortuous, malicious, sinister, and done in bad faith with full knowledge of law. In such conduct, after the U.S. Patent and Trademark Office's initial refusal to above registrations of the name, shows there was willful infringement that invokes Lanham Act damages. Plaintiff demands judgment against William Roberts, Jay-Z, Def Jam, Universal Music Group in excess of $10 million, exclusive of interest, costs, attorney fees, compensatory, punitive, statutory, and treble damages, retroactive to October 2006, other injunctive equitable relief, preventing defendants from use of plaintiff's name in commerce, domain name changes, asset freeze on defendant Roberts' royalties, prohibit defendant release of 2010 music projects in Rick Ross's name, and formal accounting of defendant's profits for willful infringement. Just spoke the Freeway Rick. Interview coming this weekend. Peace.